Today we're going to talk about examinations for discovery in personal injury actions or lawsuits in Ontario. There's something that happened in virtually all personal injury lawsuits in Ontario and in every single serious personal injury lawsuit in Ontario. For my clients that are watching today, rest assured that you'll be getting a letter shortly, if you haven't received it already, setting up a meeting, because today is just an overview of the examination for discovery process. Stick around to the end of the video where I'll give you 3 tips that apply to any examination for discovery. So let's get to it. First, what is an examination for discovery? Really what it is a question and answer session between you answering the questions and an insurance company lawyer asking the questions about things that are relevant to your lawsuit. Now let me talk about 3 things that you need to know before we get into what happens the day of the examination for discovery. The first thing you need to know is that before the examination for discovery, the insurance company's lawyers will have received a whole bunch of medical documents and investigation materials from police or other places and have fully read them. So they're not coming at your case cold turkey. They'll know all about it. The second thing you need to know is that I'll probably have had an opportunity to ask questions of the defendant or the at-fault party before your examination for discovery. You're not there for that part. I do that strictly with the insurance company's lawyer and the at-fault person themselves. The third thing that you need to know is that there is a basic rule for examinations for discovery. And the basic rule is that anyone can only ask questions that are relevant to a person's lawsuit. Who determines what's relevant? Well, if I'm your lawyer, I'm sitting beside you, and I object to any questions that are irrelevant or inappropriate. So let's turn to what the discovery is all about. First thing we need to know is that before the examination for discovery, if you're one of my clients, I'll have met with you probably a few days before the examination for discovery for maybe an hour and a half, going through things to do, things not to do, and preparing you fully so that you can go in prepared and reduced in your level of anxiety that I know most people have. Second, let's go to the day of the examination. It'll happen in something called a court reporter's office. And it's called a court reporter's office, but there's no court, there's no judge. All there are is court reporters for the most part. And really, it's just a bunch of boardrooms. I'll take you into the boardroom and you'll meet the court reporter of the day. It will be a long table, and on one side of the table, there'll be you and I sitting, and on the other side of the table will be the insurance company's lawyer. At the end of the table will be a court reporter. So let me tell you about everybody's roles that day. The first is your role. You'll be asked to swear to tell the truth or affirm to tell the truth at the beginning of the day, and your role then is to answer questions that are asked and, frankly, not answer questions that I object to. Next, my role. My role is to ensure that you only answer appropriate, relevant questions to your lawsuit. What's the insurance defense lawyer's role? Their role is to ask you questions that will help them assess your case, the value of your case, and your credibility. At the same time, they want to gather any helpful admissions, things that help their client in the case. And finally, we have the court reporter. The court reporter's role is to record in one way or another the questions that are asked and the answers that are given. Sometimes they do it in writing, sometimes they do it by talking into a particular machine. They have various different ways that they do it. At the end of the day, In most cases, a transcript is made by the court reporter. So it's really important during the examination for discovery that if your answer to a question is yes or no, you say yes or no as opposed to or because on that transcript, no one will know if that was a yes or a no. Let's move to some typical areas that an insurance company lawyer will ask you about in a personal injury case. Now listen, every case is different, and this is just an overview, but here are the typical areas that they will ask about. First, they will ask about whatever incident or accident led to the lawsuit. They'll ask about the time of day, the lighting, the weather conditions, all of your observations. They'll ask about alcohol or drug consumption. They will ask about all of your recollections of conversations that you may have had with people at the scene. Next, they'll ask about what your health history was like before the accident. And here they're really wondering about whether you had any conditions before the accident that may affect your lawsuit. Next, they'll ask about your injuries and impairments and how they impact on your activities of daily living. Do they prevent you from doing certain things? Do certain things take longer? That sort of thing. Does it impact on the way you do your job if you've returned to work? Have you not been able to return to work? All of those sorts of questions in terms of your abilities and the impact of your injuries. Next, if you have a loss of income claim, which every serious injured client will have who'd been working before, they will ask about your education background, your employment history, and they will probably have at that time your income tax returns. Finally, they'll ask about any accidents or incidents you've had since the accident that led to the lawsuit, just to make sure that there aren't other factors which are playing a role in the valuation of your case. So that's a general overview of examinations for discovery in serious personal injury cases in Ontario. Let me leave you with 3 tips that really apply to every examination for discovery. Some of them may seem simple, but many people get themselves into trouble because they don't follow these rules. First is tell the truth. I see it when I'm examining defendants or the at-fault parties all the time. They get themselves into trouble when they don't tell the truth. Second is don't guess at an answer to a question. Guessing doesn't help you, it doesn't help anyone. So an example might be if you're asked a distance between when you saw another car before a crash, and you think to yourself, I'm really bad at distances, and you just guess that it's 100 meters when it was in fact 50 feet. You're not helping yourself, and you're not helping any of the parties involved, and in fact, people may begin to question whether you're credible and truthful. Finally, the third tip is it's okay not to remember the answer to a question. I've been doing this for 20 years, and rarely do I do an examination for discovery where someone remembers all of the answers to a question. That's not how our minds work. Things happen quickly, and it's only expected that you won't remember everything. And that's okay. So that's it, a general overview of examinations for discovery in serious personal injury cases in Ontario. If you're one of my clients, I'll meet with you soon. For everybody else, thanks for watching. We're grateful for all of our social media followers. If you like this video, please click like in the bottom right-hand corner of your screen and share it with your friends and family. Be sure to subscribe to our YouTube channel. Thanks very much for watching. We'll see you in the next video.